Technical assistance, policy guidance, and legal education to the 351 local boards of health in Massachusetts, all of whom have the legal authority to enact local public health laws. Cheryl assists municipal officials and attorneys in developing, enacting, and enforcing local regulations, ordinances, and bylaws. She and her colleagues in Massachusetts have drafted a local secondhand smoke regulation that incorporates and strengthens the statewide smoke-free law that prohibits smoking a tobacco or non-tobacco product designed to be combusted or inhaled, including marijuana. She and her colleagues drafted a tobacco sales regulation template that restricts flavored tobacco to adult-only retail establishments, prohibits the sale of inexpensive single cigars, increases the minimum legal sales age for tobacco to 21, prohibits the sale of tobacco in pharmacies, and caps the number of tobacco sales permits. These regulations have been enacted in hundreds of cities and towns in Massachusetts. She's the lead author of a local regulation template for the safe and sanitary operation of marijuana establishments and marijuana sales. She holds a Bachelor of Arts degree from Tufts University and a Juris Doctor degree from Suffolk University Law. Please help me to welcome Cheryl Sparrow.
Hi, everyone. First, I just want to underscore and attest to what was discussed this morning. I have a 27-year-old son who has been in recovery for 5 years. He started heavily using marijuana and proceeded to pain pills, opioids, but as I said, he's been 5 years in recovery. I am on the board of directors for Right Turn, which is a recovery program in Watertown, and we are seeing more and more young men coming to the program for addiction to marijuana. So everything that was said this morning, I could not agree with more. Having said that, we're going to talk about what the cannabis control regulations look like. I should first say that I am with the Massachusetts Association of Health Boards. We are a membership association that represents the 351 local boards of health in Massachusetts, all of whom have the legal authority to enact local public health laws. And one of my board members is here, Joan Jacobs from Norwood. Thanks for coming, Joan. So, let's get going. As every lawyer does, we don't want to be blamed for anything that we say, so we say that this is being provided for educational purposes only. I do not represent your cities or towns to get legal advice for questions relative to marijuana. Those are the go-to folks for you. But just in general, I know the Board of Health people here know this, but a lot of other people may not be aware of just how broad our authority is in Massachusetts. There's a statute called Chapter 111, Section 31, which is the statute that basically delegates to boards of health the authority to make any reasonable health regulation. And you can see from some of the cases that are cited up here that public health is considered within the police powers of a municipality to protect the health, safety, and welfare of its residents. It's a widely accepted function of government to protect public health, even at the expense of an individual's freedom. We're always doing a balancing test when we're looking at policies that are about local public health. The Supreme Judicial Court has upheld, I don't know of a case, except for one where the regulation was written really poorly, but I don't know of a case where the Supreme Judicial Court actually did not uphold public health regulation. The court will not substitute its judgment for the judgment of the Board of Health. So, this is a case that I really like. First, because I was involved in it, and two, because I think that the definition that came out of this case was a really good definition of what public health is. This was a case where the Athol Board of Health ended up prohibiting smoking in private clubs, which went beyond the state law, because all the private clubs, once smoking was prohibited in restaurants and bars, started acting like bars. They started having $5 memberships, advertising, come on down, where you can have a drink for $5 if you get a day pass. So we ended up going to court because they sued the Board of Health for that regulation. And the claim was that this is a private club. It's not open to the public. Therefore, the Board of Health can't regulate anything that goes on in a private club. And what the court said, a definition came out of that decision that basically said, no, that's just not true. The focus of public health is to protect the health of every member of the community. It's not about geography or about location. We regulate private behavior in the name of public health in many other areas. Just look at our helmet laws, smoke detector laws, lead paint laws. We regulate behavior when we feel that there's a need to. So here are just some more cases. In the interest of time, I'm not going to go through all of them, but all of them upheld the Board of Health's legal authority. So the chief spoke about this this morning. There are a couple of conundrums that still exist even with the final regulations from the CNB, which is the commission. One is the definition of marijuana accessories is actually almost mimics the definition of drug paraphernalia. So we have a state statute that says these are drug paraphernalia, and we have another state law that says they're marijuana accessories. Prior to this law, we were able to regulate these kinds of devices locally because we could require that stores actually had tobacco sales permits in order to carry these kind of products, because hypothetically they can also be used to consume or ingest tobacco. We can't do that anymore. So now all of these devices are perfectly legal. They can be sold anywhere. They can't be sold to anyone under the age of 21, but they can still be sold. We're going to talk a little bit about ways that localities can address that issue. Another thing that people sometimes get confused about, and it's something that I think Massachusetts did much better than some of the states that have also legalized marijuana prior to when we did, is that the law states that you can't consume marijuana in public. So we're not going to have hemp fests because that's an open public place. You can't smoke it or eat it or drink it in any public place. In addition to that, you can't smoke it anywhere that you can't smoke tobacco, because of our definition in the smoke-free workplace law says that smoking is defined as anything that can be combusted or consumed. The only loophole that we see right now with that is in municipalities that have not prohibited smoking in private clubs. Worcester has a private club that's opened for cannabis. They don't have any regulation on smoking in private clubs. So that might be a local strategy that you might want to consider in the future. It's not an issue now. The law itself, Section 94G, states that it's not a preemptive law, which means it does not prevent cities and towns from further regulating marijuana. The local law would have to be, it could not be unreasonably impractical. There's a little confusion about what that actually means, but it basically means that the law can't be so onerous that an applicant wouldn't want to operate a marijuana establishment in that city or town. Another bit of a conundrum is The edible marijuana products are now subject to the food code, which includes good manufacturing practices, food handler requirements, isolation and quarantine. However, the law, also the DPH regulations, which address medical marijuana, which will all go away as of December 31st of this year, claim that edible marijuana is not food. So it's an edible, you eat a brownie, but it's not food for purposes of the food code. So that we're not sure how that's all going to pan out, especially in these dispensaries that are now going to be selling both medical and commercial marijuana. The regulations that the CNB adopted, there are, as the chief said earlier, there are a lot of really good sections in them. Some of them here are, the products have to be lab tested, they have to be, have their own batch number, they have to say what the percentage of THC in each serving is. I don't know how that's gonna look, but they also have to make it clear that they're not FDA approved because they're still illegal federally. We don't have to be as concerned with putting into place some advertising restrictions with tobacco because tobacco is a legal product. That means that tobacco companies have a First Amendment right of commercial free speech, but because this product is still illegal on the federal level, that's not as much of, that's not as important for, we don't have to really think about that too much. The regulations do prohibit, the gummy bears that you saw earlier. You can't, edible marijuana cannot be in a shape of any sort of animal or, they basically have the same restrictions that we do for tobacco when it comes to advertising. The products can't be kid-friendly. You can't have something that looks like a Snickers bar but isn't called a Snickers bar. So the final regulations that the cannabis control, these are just some of the things that stand out, is that they are completely silent now on social consumption and on home delivery. The estimate is that the Commission will not start regulating those until 2019 at the earliest. However, if social consumption establishments are coming into a municipality, and the Commission wasn't aware of this when they wrote the regulations, that some of the members have told me that. Because of our smoke-free workplace law, you can't smoke unless you amend the state law. And the legislature is not of a mind to amend it. They're amending it right now to include vape products in the definition. They're amending it now so that you won't be able to use vape products wherever you can to smoke. So they would have to amend that law in order to allow smoking in these establishments. We also do something, this morning we talked a lot about diversion and what an issue it is in some of the states and how it's brought the price of the product down so low. Our regulations limit grow sites to 2.3 acres. And the reason they did that is to hopefully prevent diversion. There's also a regulation, a section in the regulation that says if you are not utilizing all of your grow space, or if you're not able to grow all of that, or you're not able to sell everything that you said you were going to sell, the Commission can limit your license to whatever amount you actually are able to get to sell. So that's another way to try to get down diversion issues. So right now, we talked about priority applicants, and the dispensaries are a priority because they're already up and running. I would venture to say that the reason a lot of these people opened medical marijuana dispensaries is because they knew that this would be coming, and they were all set up to work, so they would get first dibs, sort of like big tobacco. The other applicants are the economic empowerment applicants, and they are supposed to be applicants that can demonstrate that, that they are going to be promoting economic empowerment in areas of disproportionate impact. And I know Chief Carmichael mentioned, and Jody, I think, mentioned the report that the commission used to determine which of these applicants would meet that, which of these cities would meet that criteria. And what they looked at was not only the arrest rate, but also the poverty level and the unemployment level. Most states also looked at racial inequity, which is really, people of color are the ones that have been disproportionately affected by some of the marijuana laws in the past, but it does not appear, and I just glimpsed at the report, but it does not appear as if that was considered when they were looking at some of these. Some of the municipalities you would figure, like Boston, Worcester, Springfield, New Bedford, those all make sense. I'm not exactly sure where Walpole fits. In order to successfully complete your application, you need to submit a certification signed by the municipality that evidences a community agreement, a local agreement, and you need to conduct a community outreach meeting. Here's where, in addition to the 30,000 that was mentioned earlier, here's where some cities and towns are seeing this economic potential in what the establishment proposes to give the town in exchange for having a retail establishment in that town. But the regulations, again, are not preemptive. So in that agreement, they also have the applicant has to demonstrate and agree to comply with whatever local laws are enacted, including Board of Health regulations. So the first, we already talked about the first one, the conundrum with whether a medical brownie is food and a commercial brownie is commercial brownie is food and a medical brownie is not. Law enforcement authority, it wasn't clear in the original regulation, it's clear now that whenever they're referring to law enforcement, they're referring to local law enforcement. And again, we don't know what's going to happen with medical marijuana because it's going to be moved over to the treasurer's office, and we don't know whether they're going to bring the DPH regulations with them, whether they're going to create new ones. It's just uncharted territory. The fee structure is much different than the fee structure for medical marijuana. It's much, much lower. Other parts, there are stringent requirements for the handling of marijuana. As I said, it's subject to the food code. I'm not going to go through all of those things. And it also really protects local jurisdictions and their legal authority. Security plans and procedures have to be shared with the local police department. And they mirror some of the DPH security requirements in the medical marijuana program. And again, these are standards that these products need to meet. I'm not sure, it's sort of an oxymoron. I mean, these products are already adulterated with THC, but they have to comply with the food code. So I'm not sure how that's going to play out. As was mentioned earlier, the single serving size has to be 5 milligrams, which is much less than other states, and multi-servings have to be easily separated. Like if you had a Hershey bar and they have little pieces, that's how a multiple serving has to be sold. So you wouldn't buy a whole cookie and a serving size would be a quarter of it. That just doesn't make any sense. So that's a lessons learned also from other states. I was in Portland, Oregon, doing a presentation on marijuana last week, and my husband and I went into a gift store, and there was a cookbook there, and I opened it up. I don't know if you can see this, but this is a recipe for cannabis juice, and it says, I can't even see it on my slide, it says serving size. It was for 16 to 18 people. It was like a big thing of cannabis juice. And it said THC per serving, 25 milligrams.
Wow.
We have 5 is per serving, and this was 25 per serving. Here's the really good news, is that we can do things locally to strengthen the laws around these establishments. And also, you'll see that the inspections, this is one of the main reasons I suggest if marijuana establishments are coming to your city or town, I would suggest that you talk to your city or town attorney about considering a local regulation. And the reason is, this is the protocol for enforcement for the state. Right now, this is a state regulation, and the only enforcing authority in that regulation is the state. They will have their own inspectors that will be responsible for enforcing this regulation. I know a lot of you in this room deal with state agencies that have enforcement authority just as frequently as I do, and from my experience, if the state is the only enforcing authority, there's no enforcing authority. You know, they really don't have the resources to come out and do compliance checks to make sure that no one under the age of 21 is able to enter these establishments, and to make sure that the product is behind the shelf or whatever requirements you may want. And you can get waivers from the regulation if the requester can actually demonstrate that non-compliance would not jeopardize the health or safety of any patient. So, let's look at what we could do locally. First, why would we want to regulate locally? One of my main concerns is that we are able to locally do compliance checks to make sure youth are not even permitted to enter these establishments. They should not, by law, be able to enter them. And also that the product is cleanly cultivated and distributed. Also, I think we can address locally this conundrum surrounding the marijuana accessories / paraphernalia. A suggestion would be to limit the sale of marijuana accessories to marijuana establishments and adult-only tobacco stores. Just a thought. And again, I talk to your city or town attorney about this. I also think it would be really helpful if boards of health could establish operating permits for these establishments, so that if you find someone selling to a minor, or if you find someone selling contaminated product, or in some other way violating the food code, that there would be a local enforcement strategy, either a fine, or a hearing, or a suspension of a permit, but that there would be something that you could do locally. And also, there are many tobacco control strategies that might also be relevant for marijuana. For instance, do you want self-service displays? Maybe you don't want self-service displays in these establishments. Do we want vending machines of marijuana? Probably not. So here are some strategies that I think are no-brainers, but again, you need to talk to your city or town attorney about that. But incorporate the whole regulation into your local regulation so that it gives you the enforcing authority. And then also incorporate those pieces of the food code that that the establishments are already subject to. Then requiring an operating permit for all types of marijuana establishments. And in that regulation, because we're unsure what's going to happen with medical marijuana, you might want to include medical marijuana in your in any regulation. Other strategies, and this came up at some of the hearings before the commission, when at least the ones that I was at, there was a concern about the smell that might come from some of these manufacturing plants, or the irritation to someone who lived next to someone else who may be smoking or vaping marijuana outside. A lot of those things can be handled through our nuisance law, so that could be incorporated into a local regulation, so that you would at least have the authority to order someone. If you're getting a lot of complaints, it may rise to the level of a public health nuisance. And then, ban out of package sales, displays, the things that you see frequently in tobacco control regulations. We prohibit the distribution of coupons for marijuana, which are going to come out. Prohibit, and I know you can gift marijuana, but you could prohibit the commercial sampling of marijuana. And again, if you're issuing operating permits, you clearly can't violate anyone's due process rights, but if you are granted a permit to operate, that is a privilege, not a right. So there's a lot of merit in looking at requiring a local permit. Strategies that may be a little more controversial, but you might want to think about, are also permitting the agents and the employees. That might be too onerous for local boards of health to do, but I was asked to keep that in there. It's something that some municipalities have thought about. We talked about the marijuana accessories. One municipality has a legal opinion from its attorney that says that it does have the legal authority to increase the minimum legal sales age to 25. I'm not so sure about that. Unfortunately, the way the ballot question was written, it said the ballot question was written by the industry, and it says treat marijuana like we treat alcohol. Alcohol's 21. Belmont did it. Belmont did it because their attorney said they could, not because I suggested it. You could also add, and again, this is sort of a challenge because I'm not sure how you would define these, but youth centers, preschool programs, you could add those to the 500-foot buffer zone that now is just around elementary and high schools. And you could also prohibit marijuana establishments from holding a tobacco sales permit. In other words, you want to make the store just, like I do this all the time because I work in tobacco, but our goal in tobacco, other than to eliminate it, is to have just, this is a death and disease store. That's all they sell, is death and disease, nothing else. So you would take that same philosophy and say, this is a THC store, that's all they sell. So you wouldn't allow them to sell tobacco or alcohol would be another thing that you would you might want to consider doing. These are strategies that I think will be challenged legally, but I was asked by the working group that I was a part of to put them in as options, and again, you need to talk to your city or town attorney about it. The grow your own operations, they're becoming an issue, especially in multi-unit dwellings. Mold, odor, there are lots of issues involved with that, but there are also a lot of privacy issues. So that is a strategy that would be very resource intensive for boards of health and also would probably be challenged. And eventually, you know, we're prohibiting flavored tobacco products because the industry told us that they were geared toward children in their documents, their private documents. So we may at one point want to consider prohibiting flavored marijuana, just a thought. In closing, I'm just going to show you something else that we found in that gift shop. This is a cannabis roasted chicken with onions, carrots, and pepper. So that's it for me.